All right, well, normally I get up at presentations and I apologize for being a lawyer, but frankly, I'm following a meteorologist who just told you there was a drought, so maybe I'm better than that guy. I do start my programs by admitting up front that I am an attorney, and so I always bring pictures to defend myself because before I was a lawyer, I was a farm kid. I grew up on my family's farm and ranch out in northeastern New Mexico. We raise cattle and sheep and have some irrigated cropland out there. Perhaps more importantly, or what more people are interested in now, is that I'm raising a couple of farm kids. I have a 2-year-old and a 1-year-old, so my life's chaos. And you know, as you're raising these kids on a ranch and we think we're teaching them things, we're never quite sure what they pick up. Over Christmas, we got this picture of my son. He went into the kitchen and he got an oven mitt and put it up his arm and he preg-checked his cow. We feel like that's a parenting win and we're just going to quit now. So that's the lifestyle that we're living at our house. I have to give you a little disclaimer. I'm going to give you some general information today on water law. I can't give anybody specific legal advice. If you need that, you have to talk to your own attorney. So we're going to start off with just the basics of water. So in Texas, the type of law that applies to water depends on the type of water that we're talking about. And so we put water into a couple of categories. The first category is groundwater, and that actually is has 2 subcategories underneath it. But for our purposes, groundwater pretty much means water percolating in an aquifer beneath the ground. We also have surface water, and again, there's kind of 2 subcategories within that. We have regular surface water and diffused surface water. We'll talk about each one of these and the law that applies. So when we're dealing with groundwater, who owns the groundwater in Texas? The landowner, right? The Texas Supreme Court and the Texas legislature have made very clear, in Texas, the landowner owns the water beneath his property. More specifically, it is generally the surface owner who owns that water. If you have severed mineral rights, the groundwater goes with the surface, unless that's been severed off separately. And so we see some of that now, where potentially we have a mineral owner, we have a surface owner, and we might have a third groundwater owner who all own interest in that one property. Groundwater in Texas is governed by the rule of capture, and that came about in a case called the East case. I don't think any relation to the family we heard about at lunch. The East case back in the 1900s. And essentially what the rule of capture says is a landowner has the right to capture water on his or her own property, even if that damages their neighbor. So in the East case, what happened, Mr. East owned his land, had a well, he was pumping water, life was good. The railroad company moved in next door, purchased the property there, and they drilled a bigger, deeper well. What happened? Mr. East's well goes dry, right? So he's not very happy. What does he do? He sues them, right? He's a good American. Files a lawsuit. And his legal theory is pretty simple. I had this water, they came in and damaged it, I should be able to recover damages in court. But the court said not in Texas. In Texas, you have no remedy at law if your neighbor makes your well go dry. No remedy at law. What's your remedy? You can go drill a bigger, deeper well. Right? And because of that, there are some scholars that refer to Texas water law as the law of the biggest pump. I think that's comical. A couple other cases I want to mention real quickly with regard to water law that are important are the Day case. That case was decided by the Texas Supreme Court in 2012, and it confirmed that landowners own the water beneath their property even while it's still in place. So they have ownership of the groundwater even while it's still in the ground. All right? The other big case that followed that was a case called Bragg versus the Edwards Aquifer Authority. And in that case, it was an interesting issue dealing with whether or not the denial of a permit to irrigate could be a constitutional taking. So what happened in the Bragg case is we had a pecan farmer who purchased property in Medina County, which overlays the Edwards Aquifer, in the 70s and 80s. At that time, he planted pecan trees, so he had 2 orchards. In the 70s and 80s, there was no groundwater conservation district, no Edwards Aquifer Authority, no one managing groundwater in Medina County, so he just irrigated as he saw fit. One orchard he irrigated with Edwards water. The other orchard he irrigated out of a different aquifer that was shallower. So he did this for a couple of decades, and then in 1996, the Edwards Aquifer Authority was created, and they're not the same as a groundwater district. They're different, but they're similar in purpose, all right? Created by different statutes, but they manage withdrawals of water from the Edwards. And when they were created, they said, landowners, if you want to irrigate with Edwards water, you've got to come get a permit from us. And we're going to give you permits based on historic use. So if you can show historic use of groundwater, you'll get a permit. If you can't, you won't. Well, so Mr. Bragg filed permits for both orchards. On the one orchard, he had historic use, but he asked for double the amount of water that he had used during the historic period. For the other orchard, he had no historic use. So the Edwards Aquifer Authority reviews his permit request, and it's denied in part and denied. So for the orchard with no historic use, they said you cannot irrigate with Edwards water. For the other orchard, he was given half of the water he requested. If you're the landowner, you don't like that very much, right? So Mr. Bragg filed his own lawsuit against the Edwards Aquifer Authority with an interesting legal theory, which was, I am a landowner, which means I have a property interest in the water beneath my land. The Edwards Aquifer Authority is a governmental entity. They are telling me by regulation that I cannot use my water. Therefore, the government has taken my private property right in that water. And what does the government have to do when they take private property? They have to pay just compensation. And so that was Mr. Bragg's legal theory. And the trial court agreed with him and said, yes, a taking occurred, and Mr. Bragg is owed just compensation. The San Antonio Court of Appeals affirmed that, and the Texas Supreme Court said, we're not going to hear the case. So what we were left with is an important decision, which is the first time in Texas a landowner won a takings lawsuit when he was denied a groundwater permit. Now, a couple of things. I want to be clear. Takings lawsuits are very fact-specific, and they're very difficult to win. So what I don't want to leave you with is this impression that any time a groundwater district denies your permit, you're going to go be successful in court. That's not the case at all. There's a very complex balancing test courts look at. They have to weigh various factors. Those are tough cases to win. But the Bragg case tells us that can be done. And so when they went back to the trial court to calculate what just compensation was, the court said that the way you do that is you look at the difference in property value between the property with the water Mr. Bragg requested, so an irrigated property, versus a property with the water he was given or not given in the case of one orchard. And Mr. Bragg got the difference in the two. Make sense? That ended up being about $2.5 million. Okay, and when you added in attorney fees that he was able to recover, it was about $4.6 million. So it was a big case. It lasted for about 12 years, but we do have a takings verdict now in Texas. There are a couple of limitations on the rule of capture. So like I said before, the rule of capture governs groundwater in Texas, but there are a couple of big limitations that you need to be aware of. The first are a set of common law exceptions. These are judge-made laws that came out of cases. To be frank with you, these don't come up very often. There are things like you can't trespass on your neighbor's property to drill a well. You can't drill a well if the sole purpose for doing so is to harm your neighbor. I like to call these the don't be a jerk rules, okay? We don't see many cases on these. The bigger issue is groundwater conservation districts. And we'll look at a map in just a minute, but the Texas legislature under the Constitution was tasked with managing Texas's natural resources, and they decided that management for groundwater would be better in local groundwater conservation districts rather than having like a state groundwater agency or something that managed groundwater in Austin. All right, so groundwater conservation districts are the ones that enact rules. They're the ones who handle the permitting process in local areas. We've got about 100 of them in Texas. We'll look at a map in just a minute. They cover about 85% of the state's groundwater. Now that means there are some areas, and there are some areas in the Panhandle, where there's not a groundwater conservation district, right? And we'll talk about what that means in just a moment. So groundwater conservation districts have to require a permit for the drilling or operation of any well in the district. They have to require that driller's logs be kept and filed. They may require you to file various records and reports of drilling and groundwater production. They may have rules like spacing rules. Your wells have to be so far from the property line. Wells have to be so far from each other. And they may have production rules. You can only produce so many acre feet, etc. The other thing they may do is impose export fees if you're going to produce groundwater and then export it for use outside the bounds of the groundwater conservation district. Like I say, there's 98, 4 are currently pending confirmation, and here is the map. And so you'll see on the map, anywhere that has a color is a different groundwater conservation district. Anywhere that's white is not covered by a district. So if you are in a white area on the map, that means the only rules regulating your groundwater use are those don't be a jerk rules we talked about. If you're in a colored area on the map, you've got to follow the rules of the district that your property is in. And here's where things get real tricky. We have 98 districts. They each make their own rules. So that means we have 98 sets of rules in Texas that govern groundwater. All right? So for example, I know a rancher up in the further north in the Panhandle who owns a ranch that's the same contiguous ranch falls in 2 different groundwater districts. The rules are different depending on where he wants to drill a well on his ranch, what he has to do. Production rules are different. All right, so that can be complicated because we have all of these different rules for different groundwater conservation districts. So like I say, the biggest thing to know is, number one, are you in a district? And if you are, you've got to look at that district's rules regarding drilling of wells, production, spacing, etc. One important thing to note is that statewide there is a Texas statute that designates some wells what we call exempt. And what that means is if you have one of these types of wells, your groundwater conservation district cannot require you to get a permit to drill it. All right? So for example, and this is statewide, so every one of our 98 colors, this rule applies in. All right? So there is no permitting necessary if you're going to drill a domestic or a livestock well. If you're on 10 acres or more, and so long as it cannot produce more than 25,000 gallons a day. If you're going to drill that, you don't have to have a permit from your groundwater district. Now you may still have to file some reports or get your driller's logs, etc., but no permit to do it. All right? There are some other exceptions, one dealing with oil and gas operations and one dealing with mining. Now, this is a statewide, I call it a baseline, because an individual groundwater conservation district could expand the exceptions and make it broader. Can't make it less, but it could make it more. So for example, there are some groundwater districts that say any domestic well is exempt. Any livestock well is exempt. We don't care about the 25,000 gallons a day or 10 acres, right? So again, you've got to look at those rules in your district. There's the Bragg case. We already talked about this, so we'll skip right past that. The other case that's not up here that I want to mention, and this is just brand new in litigation, but there's a situation down around Bastrop, the Lost Pines Groundwater Conservation District. What's going on there is there was a water company that came in, leased up some rights, bought some property to own groundwater rights in that area in the Lost Pines Groundwater Conservation District. And back in, I think, 2016, they filed a permit to start producing water from the Simsboro Aquifer in Bastrop and Lee County, so outside of Austin. They're going to produce water, and they're going to pipe it into some of the cities surrounding Austin. I think Hayes might be one, Buda around there, and sell it. And so to do that, they had to go get a permit from the Groundwater Conservation District. They wanted to pump about 46,000 acre feet a year. That's a lot of water, all right? So they requested a permit. Well, when the permitting time happened, there were 4 landowners in Lee and Bastrop counties who wanted to object. They wanted to be part of the permitting process. They wanted to be heard. They wanted their chance to say, hey, we don't agree with this. We are landowners, therefore groundwater owners, and we want to object to this permit. In 2016, the Groundwater District decided they did not have standing to object. And the reason was because those landowners were not currently producing water from the Simsboro Formation. So essentially they said, you're not pumping water, so you can't object to these other people pumping water from that aquifer. Within the last month, a trial level court in those counties has decided that the district was wrong, that those landowners should have had standing to object. They should have had a seat at the table, regardless of whether they were pumping that water, because they did have an ownership interest in it. And so the court has issued an injunction that says, hey, water company, you can't start producing this water and pumping it out. Permits yanked. You've got to go back again, redo the permitting process, and let these landowners have a seat at the table. Again, trial court decision, so it could certainly be appealed, but I think that's an interesting thing to be aware of going on down around Austin. The other case I want to mention hits a little close to home here in Lubbock, and that's the city of Lubbock versus the Coyote Lake Ranch. What happened here is what we talked about a little bit earlier. There was a ranch kind of over near Muleshoe that had groundwater, and it severed those groundwater rights and sold them to the city of Lubbock in 1953. So at that time, they issued a deed that said Lubbock is now the groundwater rights holder, and they have the right to come on the property and produce the groundwater, right? And so that happened in 1953. In 2012, city of Lubbock comes knocking on the door and says, hello, we're here to drill about 65 groundwater wells on your ranch. Guess what? The ranch had changed ownership since then. The new owner's not real happy about this situation, particularly because he didn't get any of the money from the city in the 50s. So he says, hey, this is a problem. Now he knew when he bought the property that the city owned the water rights, that's in the deed. But he went to his lawyers and said, we got to come up with some sort of argument here to at least limit where they can drill. Because they kind of wanted to drill all over the ranch. I think it was 65 wells. It's very sandy soil. They were concerned about them ruining the pasture for the cattle, etc. They go to their lawyer, and their lawyer decides that they are going to argue something called the accommodation doctrine. The accommodation doctrine has only ever been applied in Texas oil and gas, and essentially what it says is that a mineral owner, since this is an oil and gas doctrine, says a mineral owner has to accommodate the existing surface user when he produces the minerals if 3 conditions are met. There will be a substantial impact on surface use, the mineral can be produced another way, and the surface use cannot be made another way. Let me walk you through the classic case of this. It happened here in the Panhandle. There were some brothers that owned center pivot corn. They grew corn, and they did not own the minerals. Oil and gas company leases up the minerals. They come in, want to drill an oil well. Guess where? Right in the middle of the circle, right out in the corn patch. And the brothers say, okay, well, you have the right to do that. Under Texas law, you have an implied right to use the surface, but they said you have to accommodate our existing surface use, which means you need to put in not a drilling rig, but a pump jack that is less than 11 foot tall. Because if you do that, then our pivot can still run. Okay? So that case was when this doctrine was established, because there they could show it would be a substantial impact on their existing surface use. They could show the mineral could be produced another way. In fact, they brought in evidence that said they make shorter pump jacks, or a guy down the road dug a hole and put the tall pump jack in the hole, and that worked. Okay? The other thing they could prove is that the surface use could not be made in another way. They showed there was no other way to irrigate the corn. Okay? That case happened, I believe, in the late 40s or early 50s. I want you to guess how many landowners have won on that theory against oil and gas companies since then. 0. Right? But it exists. And so in this case, the landowner at Coyote Lake Ranch said, all right, we think the accommodation doctrine should apply to groundwater. And so, yep, the city of Lubbock has the right to come in and drill these wells, but they have to accommodate our existing surface uses, and we have a say over where some of those go. So we end up in the Court of Appeals. The trial court initially issued an injunction. The Court of Appeals in Amarillo reversed. They said the accommodation doctrine's never been applied to groundwater. If the Supreme Court wants to do this, they can. We're not doing it. Well, the landowner took that invitation and went right to the Texas Supreme Court, and they did exactly what the Court of Appeals said. And they said the accommodation doctrine can apply to landowners, to groundwater owners, but they took it a step further. They also said that groundwater is a dominant estate when severed, just like oil and gas. That had never been said by the Supreme Court before. So what does that mean? Well, it means that a severed groundwater owner has an automatic implied right to use as much of the surface as is reasonably necessary to produce their groundwater. So that means if I buy property and I don't own the groundwater owner can come knocking, and they've got the automatic right on my land to do things like drill wells, put pipelines, build roads, and they don't have to get my permission, and they don't have to pay me. That had never been said for groundwater before. Huge decision. Now we know that's subject to the accommodation doctrine, right? So this case goes back to the trial court, and now the court's going to look at those 3 factors we talked about to decide if the accommodation doctrine applies to this case. We know that it can apply to groundwater, but will they win? So can those landowners show a substantial impact on an existing surface use if Lubbock comes in and drills their wells? Can the landowners show that the groundwater could be produced another way? Can the landowners show that the surface use could not be made in a different way? We'll see. That's where we are in the case. All right, I think important for landowners to be aware of that. All right, we're going to shift gears and go to surface water. All right, that's that second category that we talked about. And there are kind of 2 types of surface water in Texas. So let's cover that briefly first. We have what we call regular surface water, and then there is diffused surface water. All right, regular surface water, that is water that is in a defined water course in Texas. So that's things like rivers, streams, things like that, all right? Here's where it gets a little tricky. And I didn't make the rules. Don't shoot the messenger, all right? Me and the meteorologist, it's not our fault. A defined water course under Texas law has 3 categories. Has to have a defined bed and bank, a current, and a continuous source. Okay, so if you've got a waterway with a defined bed and bank, a current, and a continuous source, that is defined as surface water, and in Texas, that surface water is owned by the state of Texas. All right, now here's where this gets tricky. That seems like a 3-part test. Okay, we can apply that, fine. But we've got Supreme Court cases that say things like, well, a defined bed and banks, yeah, but you don't have to actually see that. Seems like, okay. And then they say things like, well, it has to have a continuous source of water, but it's okay if that source is rainfall that happens 6 times a year. And it's also okay if the current only flows when there's water in the stream bed. So my point is, courts have given this a very broad definition of what is surface water. And that means there's a very broad definition of what is owned by the state. And if you want to use that surface water, even if it crosses your private property, you've got to get a permit from the state to do that in most cases. So let's walk through that. Okay, we're going to talk about that. The other type of surface water is what we call diffuse surface water. That's like sheet flow when it rains. When it rains and we have the sheet flow runoff before it gets into a defined water course. All right? Before it gets into that water course, that sheet flow can be captured and used by the landowner as he wishes. Right? So I like to tell people, you want to go dig a big hole on your property and wait for it to rain? Go for it. Catch the rain. You can do what you want with it. Right? Now, if you dig that big hole at kind of the lower end of a creek, and that water runs into the creek and into your hole, now we got a problem, because that may be state-owned water if that creek is a defined water course. You following me? There's no cut and dry answer on this. All right? So surface water, you have to obtain a permit from the TCEQ. That's the Texas Commission on Environmental Quality. If you want to use surface water, that's the general rule, subject to a couple of exceptions. Groundwater, we talked about being governed by the right of capture. Surface water is governed by what we call prior appropriation. Put very simply, that means first come, first served. So if I go today and say I want to irrigate out of this state-owned creek, I need a permit to do that, they're going to stamp my permit with a priority date of January 2018, right? If our meteorologist friend Brian had gone in 2000 and got himself a permit to irrigate out of the same creek, his is stamped with 2000. In a time when we have plenty of water, nobody cares about the rules, right? But when we have a drought happen, 2012, 2013, now these rules become real important, because the way prior appropriation works is a senior water rights holder gets all of the water they're entitled to before a junior user gets any. So let's say Brian's got his permit from 2000, I've got my permit from 2018. If we're in a shortage of water, I will get cut off. They will curtail my right, tell me I can't pump, and Brian will get all of his. Now, if there's a senior user older than Brian, they get all of theirs and they'll cut Brian off. Does that make sense? So that's how prior appropriation works. There are some emergency exceptions that apply to that in the statute that are designed to protect public health, safety, and welfare. There are a couple of, like we have exempt wells, there are some exempt diversions under the state statute, so this applies statewide. There are no permits necessary if you want to divert water and you fall in the following categories. Okay, this means you don't have to get a TCEQ permit if you're on a non-navigable stream. Now put a little star by that. We're going to come back to what that means in a minute. That's where things get real interesting, okay? So here you do not need a permit from the TCEQ if you're on a non-navigable stream and you want to divert water for domestic or livestock use. You can build a diversion up to 200 acre-feet. It says for a non-commercial purpose, but that's a dumb definition because things like ranching are considered non-commercial. All right, so you want to water your cows out of the creek that flows across your property. As long as it's non-navigable, you're good to go. Okay, don't divert more than 200 acre-feet a year. You can also do this for commercial or non-commercial wildlife management, including fishing. Right, so that's an option. Then there are a couple more dealing with coal mining and petroleum. Okay, so I said you can do those exempt diversions on a non-navigable stream. Let's talk about what that means. Navigable streams in Texas, we care about this for two reasons. Number one is, can you have an exempt diversion? Number two is, if you have a navigable stream, the stream bed is considered owned by the state of Texas. And that means it is open for use by the public. Now bear with me, nobody likes this part. Okay? What that means is if you have a creek that flows across your private property and some hippie from Austin wants to bring his kayak and kayak through your property on your creek, if it's a navigable stream, that is public property and he has the right to do so. Okay? I don't like it. That's the rules. So that's why it matters. Here are the tests. There are 2 tests under Texas law to decide if a stream is navigable. If it meets either of these, it's a navigable stream. The first one is called navigable in fact, and courts look at whether that stream could serve as a highway for commerce. If a boat can float down it, it's navigable. There are some court cases that say if you could float logs down it, it's navigable. Okay? The other option is called navigable in law, and that says, does the stream maintain an average width of 30 foot from gradient boundary to gradient boundary? So we're looking at the average width of the stream bed. Which begs the question here, what if I have a 50-foot stream bed that's dry? Is that still considered a navigable stream? Yeah, under Texas law. So theoretically, the hippie from Austin could carry his canoe on his back and walk down the navigable stream, okay? Now, he can't get up out of the stream bed onto your private property, that's trespassing, and he can't cross your property to get to the stream, that's trespassing, but he can be in that stream bed, all right? So, keep that in mind when it comes to navigability. One case I'm gonna mention quickly, and then I'll try to wrap it up to get us closer to on time. Texas Farm Bureau versus the TCEQ. Back in 2012, drought hits and there was some concern about there being enough water for users in the Brazos River. Dow Chemical had a senior water rights on the river from 1942. They contact the TCEQ and they issue what's called a priority call, which essentially is Dow Chemical saying, hey, we have a senior water right, there's not enough water to go around, TCEQ, you have to cut off everybody junior to 1942. So the TCEQ looks at this and they make a priority call, but they make a couple of exceptions. They say we're gonna cut off everybody junior to 1942 except for municipalities and power generators. So guess who most of the people that get the curtailment letter saying stop pumping water are doing? Irrigating. Okay, about 700 irrigators get the letters. They suspended 841 rights to 117,000 acre feet a year. The exempted 19 municipalities or power generators, they pumped about 1.8 million acre feet a year. Okay, so some of these corn farmers that got cut off didn't like it. They get with the Texas Farm Bureau and they file a lawsuit against the TCEQ, and their theory is this violates the principle, statutory principle of first in time, first in right. Essentially what they said was, you have the right, TCEQ, to cut off junior users, but you can't cherry pick some of them out and let them keep pumping. If you're gonna cut them off, you gotta cut them off. First in time, first in right. TCEQ argued that they had a power under an emergency exception. The appellate court sided with the farmers and said, yeah, TCEQ can cut it off. All right, and here's the statute. It's Texas Water Code 11053, which says during a period of drought or other emergency shortage of water, the TCEQ may, look at the red, this is what got them, in accordance with the priority of water rights, as between appropriators first in time is first in right, suspend rights. Well, the court said, yeah, that says you can suspend rights in accordance with prior appropriation. It says it right there in the statute. All right, so the Texas Farm Bureau, the farmers won that case. Last thing I'm gonna give you, and I'm hoping we have a little bit of time if you all have questions, I do a blog, so if you're interested in ag law or water law, I periodically post, do some handbooks, fact sheets. We've got a fact sheet on water coming out in the next week or so. The address is agrilife.org/TexasAgLaw. I also have a podcast if you're interested in podcasts. It's kind of like a radio show, not on the radio. You can listen on your iPhone if you have an app, or you can listen at this website. Every time I have a lawyer on, we talk about a different topic. I've had Doug Karoom on. He's an attorney in Austin. He talked about groundwater law. I've had Carlos Rubenstein on. He's a former chairman of the TCEQ and the Texas Water Development Board. He spoke about surface water law. Those are available for free if you're interested. Last thing, my contact info is on the last slide. If you guys need any information, if you have questions, I'm more than happy to get those to you if you will just call or email me. With that, I'm happy to take any questions. Yes, sir. So if we have a property owner that has a creek bed across the land, they purchase the property, if it is a navigable stream, they technically do not own the surface bed because that is public property by the state of Texas. I didn't make the rule. That's one of my top 5 dumbest laws in Texas. Don't write that down, Shelley. Okay, thank you guys very much. I appreciate it.